Okay, so tell me exactly what your unit does.
My unit is responsible for doing all the appellate work in capital cases in Idaho. We also do the non-capital federal habeas cases. The appellate work in the capital arena includes the appeals to the Idaho Supreme Court, the United States Supreme Court, the U.S. District Court for the state of Idaho, and the Ninth Circuit Court of Appeals.
Okay, so how many years have you been doing this?
Roughly 27 years.
Wow. Okay. Why don't we just kind of start with the basics? When somebody is found guilty of a capital offense, we know that there's an automatic appeal to the Supreme Court, right, of Idaho.
That's correct. It's automatic. It cannot be waived. And there are certain criteria that the Idaho Supreme Court look at in that automatic appeal as far as the guilt phase. And then well, actually it's the sentencing phase. But there are three things that they have to look at that just cannot be waived. And in fact, Keith Wells, a capital case that existed prior to my being drafted for this job, thought about waiving that appeal, and he wasn't allowed to do that. The appeal was completed, and then he waived all of his other appeals, including post-conviction.
Oh, wow. So he just had the one.
He just had the one appeal. And capital cases are very, very different from non-capital cases in that you have the guilt phase, as we recently had in Daybell. You have the sentencing phase, and then instead of going directly to an appeal, you have post-conviction relief. And that initial petition has to be filed within 42 days of the entry of the judgment. Whereas in non-capital cases, you have the guilt phase, you have the sentencing phase, and then you have the first appeal. And then after that first appeal, you go to post-conviction. Everything is consolidated in a capital case.
Interesting. So for the average person watching, what does post-conviction relief mean?
Post-conviction are challenges to the defendant's attorney's manner in which the defense was provided, generally speaking. There are a lot of claims that can be raised. There are oftentimes claims that the state withheld exculpatory evidence, but generally post-conviction is a challenge to the manner in which the defense attorney defended his client.
So they're looking for any possible chance at maybe having the case reheard?
Any possible chance.
Any. And that is separate than the appeal that the Supreme Court's looking at?
Well, we'll do the post-conviction, or I say will. The post-conviction will be done. Fremont County, for example, in the Daybell case, Fremont County will actually be representing the state. It won't be my office.
Oh.
The state appellate public defender will be representing Daybell as opposed to John Pryor, because, of course, Mr. Pryor generally would not admit that he was ineffective in the manner in which he represented his client. So
Right.
you need different non-conflict attorneys to take a look at everything that took place during the trial, during the sentencing, and make sure that it was done properly.
Okay, so that's interesting. You're in Valo. I thought your office was handling like for Madison and Fremont, but I could be wrong. I thought I had heard that. But in Daybell, Fremont will represent itself on the appeal.
Well, let's get away from the use of the word appeal.
Okay, okay.
In Valo, that's a non-capital case. We've had the guilt phase, we've had the sentencing, and because it's non-capital, it goes to the appellate stage. The appellate unit within my office is handling that appeal. Whereas in Daybell, we have the guilt, the sentencing, and now post-conviction. And once that post-conviction is completed, then everything will be wrapped up into a single package and go on appeal to the Idaho Supreme Court.
I see. Okay, so Fremont's representing itself on the post-conviction.
Correct.
I see.
The prosecutor will likely handle that. I'm assuming it'll be Lindsay.
Right. Okay, so then let's talk about how long does all this take before before the Supreme Court actually it's brought to their desk and they can look at it?
We're talking Daybell or a capital case. It's going
Right.
to take a lot of time. Although the initial petition has to be filed within 42 days after the judgment has been entered, capital defendants are permitted to amend that petition, and properly so. And the reason I say that is because before the final petition for post-conviction relief can actually be filed, the state public defender's office will have to have reviewed the transcripts, the clerk's records, or record, and all of the exhibits. And it takes, in a trial of that nature, it will take several months for the court reporters to transcribe the entirety of the voir dire, of the trial, and of the sentencing. Although the sentencing, as I understand it, was fairly short.
Right. But they have to transcribe the whole thing and then turn it over to the
It'll be
appellate
turned
attorneys.
and it'll be turned over to the state appellate public defender, and I'll get a copy. And then I'll I'll give a copy to the Fremont County Prosecutor's Office so that they can defend against the state appellate public defender's office.
Wow. So really, are we talking years?
Most likely. The Renfro case, which was a murderer that killed a cop up in Kootenai County, that's been going on several years already, and we're not even close to having a final petition on that case. We're still involved at the discovery stage and trying to work through some issues up there. So yes, it in all likelihood it will take several years.
You mentioned that the defendant has the right to revise their petition. How many times? I mean, could that go on for decades?
No, it won't go on for decades, but it's not uncommon for it to be amended 2 or 3 times, because that initial petition has to be filed within 42 days from the entry of the date of the judgment. That's jurisdictional. If that's not done, then post-conviction is waived. And so it has to be waived, or has to be filed within that 42-day period. But of course, the state appellate public defender's office hasn't had a chance to even look at the transcripts or the clerk's records because they haven't been compiled.
Right.
And it's not until they can take a look at everything that took place at the trial and et cetera, that they're going to be able to know what claims should be raised in that final petition.
Okay. So then let's say it gets finally to the Supreme Court, I don't know, in a year or two, and they rule that everything was fine. They don't overturn their conviction. Then are there other appeals that can be filed?
There are many other appeals. What generally happens if the Supreme Court affirms everything is that defendants will first seek certiorari from the United States Supreme Court. That doesn't generally take a very long time, within a year. They have, generally speaking, 90 to 150 days to file that petition. My office then files a response, and the United States Supreme Court will issue a decision fairly quickly after that response is filed, within a month or two.
And I would imagine most of the time they send it back or they deny it.
Most of the time it's denied. I have not, in the 27 years I've been here, I have not had the United States Supreme Court agree to hear a single capital case. They get thousands of petitions every year. And I think this year they accepted, I think it was somewhere around 60. And so and that's not just capital cases, that's all kinds of cases, whether it be a property case, a criminal case, a capital case, or whatever, even a bankruptcy case, whatever it may be. So they don't hear very many cases, obviously.
Yeah.
If they deny cert, then it will come back to Idaho, And generally speaking, the petitioner will then file what we call a federal habeas petition in federal district court.
And what is that?
That is basically another appeal, generally speaking, raising the same things that were raised in state court, just allowing the federal court to review whether it's constitutional. Now, if it's an evidentiary error, maybe the defendant says some evidence should not have been admitted pursuant to the Idaho rules of evidence, then that's not generally going to be heard in the federal district court. It's constitutional errors, whether he received effective assistance of counsel, whether the state withheld exculpatory evidence. Due process claims are oftentimes, all of those are raised.
And how long, you mentioned the Supreme Court is 60 to 90 days. How long would this specific appeal be?
This will take several years.
Years.
They generally speaking have a year to file their final petition in federal district court. It's oftentimes filed earlier than that, but generally that amount of time. Then there is all kinds of motions that are filed, both by my office and by the federal defenders. It's not, when we get into federal court, it'll be a new organization. It'll be the Federal Defenders of Idaho that will represent a capital murder, and the SAPD will no longer be involved. But that takes a great deal of time.
Okay, so let's say after that process, they deny the appeal. Are there any more appeals after that?
There are, and you say they, it's actually one federal judge.
Oh, one, okay.
One of our Idaho federal judges. Right now, that would be Judge Nye or Judge Brailsford.
Okay.
Excuse me, I said Judge Nye, Judge Windmill or Judge Brailsford.
Right.
If the petition for writ of habeas corpus is denied, then it goes to the Ninth Circuit Court of Appeals.
Hmm.
And that is very similar to an appeal from our state district court to the Idaho Supreme Court. And it's generally just 3 briefs. There's not really a lot of motion practice, if any, and they'll render a decision once it's been argued.
Okay.
And that will be a 3-judge panel from the Ninth Circuit that's chosen randomly by lot.
And is that another years-long process?
Generally, those appeals, it's not as long as what federal district court is, but it can certainly, it's very similar to the length of time it would take with the Idaho Supreme Court, because you have to do the briefing. It takes a lot of time to do the briefing. And then you have to have the oral argument, and then the Ninth Circuit has to render a decision. It's virtually identical to what happens with the Idaho Supreme Court, but the briefs are very lengthy.
Mm-hmm.
The brief that I recently received in Roe is over 200 pages long, and then I get to write a response to those pages.
Wow. So is it after the Ninth Circuit denies the appeal, can it then go back to the U.S. Supreme Court, or is that it?
Well, they will have had an opportunity from the Idaho Supreme Court, but it's almost automatic that the federal defenders will seek certiorari if the Ninth Circuit affirms and ask the United States Supreme Court to hear it. That's certainly what happened most recently in Creech. We finished up in the Ninth, or what I thought was finished up, and then we went on to the U.S. Supreme Court.
Okay, then they deny it. Let's say they deny it. Are all appeals exhausted at that point?
No,
Still,
because for lack of better words, the appeals aren't exhausted until there's an actual execution. When we attempted the execution on Creech, we were writing briefs the day before that execution and getting decisions from the United States Supreme Court the night before the execution. There in capital litigation, there just never seems to be an end because the capital defense bar have incredible imaginations on claims that can be raised in capital cases. Things that wouldn't be able to dream of, but that I have to respond to.
Hmm.
So, when victims contact me and say, are we now done with this? Can we move forward? I never want to make that promise because there's no guarantees until the execution is completed.
Yeah. People are going to hear this and think there's got to be a way to simplify it or, take some of the bureaucracy out of it. I mean, is there any way?
I've been trying to find that way for 27 plus years. I've not been particularly successful, except in two cases. And even those took a long time. That was Rhodes and Levitt. We were finally able to execute them a number of years ago. But Creech, we haven't been successful at this point in time in executing him. And Creech, if I'm remembering correctly, currently has 3 open cases. It might be 4. So because the execution was not completed, he has now filed some new lawsuits contending that we can't execute him now because the execution last time was unsuccessful.
Yeah.
And we're defending those and we'll continue to defend those.
And so, Lamont, your job with the Attorney General's office is to defend the verdict or the sentencing of the jury to put the person to death, right? You're defending
Correct.
that all through this.
That is correct. That's what I get to do is make sure that justice is served and that the jury's verdict is affirmed throughout. And ultimately, we try to complete what the jury said to do, or some of the older cases where judge sentencing, what the judge has imposed as far as the death sentence, and have those sentences carried out.
I guess one of the ways to simplify it, like you said earlier, is if the defendant waives every appeal except that automatic one to the Supreme Court.
That would certainly simplify it. Like I said, we've only seen that happen in my lifetime one time with Keith Wells. I wasn't doing the job at the time, but he did waive all appeals except for the automatic.
When you look at other states, Texas or others, it seems like they're able to do these executions a lot quicker. Has there ever been comparisons, like how are they able to do it so quick versus in Idaho where someone could sit on death row for 30 or 40 years?
Texas is certainly quicker, much faster. They have an entirely different system than ours. And for whatever reason, I haven't been able to ascertain the exact reason. They do get through. I don't know if it's faster. I don't know if it's because their judges are faster, the litigants, the attorneys are faster, their procedure is faster. We haven't been able to put our finger on it. But even though Texas is exceptionally faster than what Idaho is, I'm not particularly enamored with the idea of doing it fast, if you will. I mean, we want to do it right. We don't want to be in a situation to be the first state in the union that executes a truly innocent man or individual. And so while I would certainly like to see things go faster in Idaho, I recognize that there's a balance there and that we need to just make sure things are done right.
Yeah, right, for sure. So, you're talking about the process. This is all if someone is convicted and sentenced to death. If it's just somebody sentenced to life in prison, and this might be outside of your lane, do a lot of these appeals go away?
A lot of them do, and it's certainly not outside my lane. Like I said, in a non-capital case, you have the guilt phase, the sentencing phase, post-conviction. there are very few petitions for cert to the United States Supreme Court. And I said post-conviction, you have the appeal between the guilt and the post-conviction. But there are very few appeals to the United States Supreme Court, and there are not very many petitions for writ of habeas corpus from non-capital cases. We do have them. Right now, I think our caseload is roughly 45 non-capital cases. But compare that to the number of appeals to the Idaho Supreme Court in the non-capital arena, and it's, I would dare say it's less than 5% of all appeals. They just don't do it. And one of the reasons, in my opinion, that they don't do it is because they don't win generally. And there's no reason for it, whereas in the capital arena, there is a very, very significant reason, and that is delay. And there are many, many appeals in the capital arena. There are many claims that are raised in the capital arena that are just nothing short of frivolous. But every day that a capital defense attorney can extend a murderer's life is considered a victory. And so it's that particularly is problematic for us.
Right. Right. Yeah. Yeah. Good point about if someone has a life sentence, then you're right that what's the point of continually dragging it out?
Now,
So
that's not to say they don't.
right.
I'm working right now on a case involving Jamie Charbonneau, who killed his ex-wife, actually. I believe it was in the mid-'80s. And that case is in front of the United States Supreme Court. They've asked me to file a response. And it's, I believe, it's probably around his 10th appeal. So it's not unheard of. You know, people say that the capital cases drag on forever, and they do. But some of the non-capitals do too. Lacey Seavick is another one that's dragged on just forever in 10 days.
Yeah.
So there are some non-capital cases that go on for what seems forever.
So at what point is an execution date set?
Once they have gone, let's assume for the sake of argument that they want to go through the entire appellate process through all the way through the Ninth Circuit in the United States Supreme Court a second time.
Yeah.
A death warrant will be sought if there are no stays in place. And a stay is something entered by a state or a federal judge that says you cannot execute this individual until this particular case is resolved. And if there are no stays in place, then the Idaho Code says that we are required to seek a death warrant. And once we seek a death warrant, that execution has to take place within 30 days.
And that's when the person is actually moved to death row, from what I understand.
That's my understanding, but I'm not involved in the intricacies of what takes place out at the Department of Correction.
Right.
And all the protocols that they are involved in. We actually have deputies attorney general that represent the department and that are involved in that aspect of the case.
Right. Okay. So the death warrant is issued, signed by a judge. Execution's supposed to take place in 30 days. And as you mentioned, there could still be appeals up until the 11th, 12th hour. And does that often happen during that 30-day period?
Always.
Always.
At least in my experience.
But are these the type where they'll be filed and quickly rejected and realistically the execution happens? Or in most cases, is it, all right, we're going to sign this death warrant, but we know it's going to be another few years?
Most cases, when what I consider to be the final death warrant, they've gone through the Ninth Circuit, etc. Most of those cases, the appeals are resolved very expeditiously, often most of the time within that 30-day window, because we're not going to execute someone who has, generally speaking, who has an appeal pending.
Mm.
Again, we don't want to be the one state in the country that executes someone and the United States Supreme Court comes back an hour later and says, oops, we are going to enter a stay. And we're not going to be that state. I have a phone line directly linked into the death penalty law clerk of the United States Supreme Court. And it's not until I receive word from him or her that there are no stays in place and everything's resolved that we go forward with an execution.
Wow.
And in Creech, for example, I didn't receive that final word until the early morning of before the execution.
Hmm.
And
Interesting.
and in the, I believe it was the Rhodes case. It was the Rhodes case. We actually had something filed at roughly 3 a.m. the morning before the execution by an attorney that had no business filing anything in the case, wasn't involved in it. And it delayed that execution for a few hours.
Oh, wow. Because you have to respond.
In that one, it was something filed in state court, and our response was very, very brief.
Mm.
And the judge said, "Yeah, this is going nowhere. It's improper." And but again, we don't want to be the state that executes someone when something is pending.
Right. Okay, so do you have any updates on Creech while you brought it up?
We're continuing to defend the death sentence, as well as all the other things that are taking place. Ada County is involved in that because he has filed another post-conviction relief petition contending that he cannot be executed because it violates the Eighth Amendment and because of double jeopardy. And we are exceptionally confident that that's going to be denied, both by the state district judge and by the Idaho Supreme Court.
Mm.
And if it goes to the United States Supreme Court, I don't have any doubt they're going to reject it too, because they have previously rejected those claims.
Yeah.
So we'll continue to litigate. We're waiting from word from the Idaho Department of Correction that the issue that arose during that execution has been resolved, and then Ada County will seek a death warrant.
Lamont, do you happen to know like statistics on the people on death row who actually die on death row before they're executed?
I don't know the actual numbers. It's higher than I would like it to be. And the reason that I say that is not because I'm adverse to someone dying after having been sentenced to dying in prison after having been sentenced to death. I just think it's indicative of the unwarranted amount of time that it takes to have these cases resolved. While I said I don't want to be Texas, I want to do everything right, we would like, it shouldn't take decades in Idaho to have these things resolved. Tom Creech brutally murdered David Jensen in 1981, and it's utterly ridiculous that his sentence has not been carried out. The same with Gerald Pizzuto, who committed his murders in 1985. It's just wrong. It's wrong for the people of the state of Idaho who have and do continue to support the death penalty, but more importantly, it's wrong for the victims in these cases to have to go through this for this length of time.
Right. And so realistically, based on the two cases you mentioned, Chad Daybell, it could be 30 years, 40 years. He could die on death row.
I can't say that that won't be true, but like I said, we're hopeful that we're always hopeful that we can get things moving along faster and still do things correctly and make sure things were done correctly.
And of course, a lot of this, or maybe the majority of it, falls on the attorneys that are filing the appeals?
A lot of it does, but you know, some of it falls on the judges uh, who take a fair amount of time to render decisions sometimes. And in fairness, sometimes I have to ask for additional time. The brief that I filed I believe it was the end of last year in what we call Hall 2, Eric Hall committed 2 murders. And now we're litigating the second murder on the unitary appeal. And, you know, to review thousands of pages of transcripts and clerk's records just takes a fair amount of time. And it took about 6, 7 months for me to file my brief.
Right.
You know,
And I think I see in Lori Vallow's case that there's been multiple requests by the clerk to have a delay because they're preparing the transcript. It's been pushed out over and over and over again.
it just takes a lot of time to get through all that stuff.
Yeah. Okay, so I want to be sure I understand it correctly. Monday morning, right after Chad Daybell receives the death sentence on Saturday afternoon, Monday morning, his attorney filed the post-conviction relief, the thing that's required within 42 days.
Actually, he didn't file for post-conviction. He filed his notice of appeal. The post-conviction hasn't been filed yet.
Oh, okay. Okay. Thank you. Okay. So notice of appeal, then there'll be a separate thing he files, which is post-conviction relief.
Correct. And his new attorneys have already filed a notice of appearance, the SAPD, and they will have 42 days from the entry of that judgment. And I don't know when Judge BOISE actually filed the judgment, if it was that Saturday or if it was Monday, but they'll have 42 days from the date that judgment was filed to file that first petition for post-conviction relief, what we call a shell petition.
Okay, and that's when his new attorneys will handle it from here on out.
Correct. In fact, they're handling it now.
Right now. So prior is basically done.
Correct.
So we have the notice of appeal filed, then there'll be the post-conviction relief filed within 42 days. But those end up kind of being bundled up together by the time the Idaho Supreme Court gets it.
That is correct.
All right.
So you basically have 3 appeals in that appeal before the United States or the Idaho Supreme Court. You have the guilt phase, you have the sentencing phase, and you have post-conviction. In non-capital cases, you have the guilt phase and the sentencing phase only.
When would the ineffective counsel appeal be filed?
That would be part of the post-conviction.
That would be part of that. Okay.
We're correct.
Then it all goes to the Supreme Court. If the Supreme Court rejects it, that basically whatever they heard, that would advance to the higher court.
That's correct.
It's not like they add other things into it, or they could.
No, they'll go directly to the United States Supreme Court if the Idaho Supreme Court rejects it.
Rejects it. And that's when then the US Supreme Court could kick it back, and then it would work its way to the one judge, then the Ninth Circuit, and then back to the US Supreme Court again.
That is correct.
And then that's the final stop. But in between, they could be adding things to it.
Yes. And that's where it gets really messy. We haven't talked about that, but they can file successive post-conviction petitions, successive federal habeas petitions, and this thing just kind of grows tentacles.
Right. I don't know how you can keep it all straight.
Well, on some of them, I have a flowchart.
I bet you'd have to.
And I certainly have a sheet that has all of my deadlines, so I don't ever miss a deadline, or so I can do something if the other side misses a deadline.
So do you actually go to the executions?
No. My job is to stay in my office and deal with the legal issues.
So it's not like you need to be a witness to be sure it's carried out.
No.
Okay.
No, there are oftentimes, well, certainly in the Rhodes and Levitt executions, the Attorney General went, and in this case, Attorney General Labrador was there, even though it was in Creech's case, even though it wasn't carried out. But if there's something last minute that comes in, it's my job to deal with it in my office. And I'm not going to be able to deal with it if I'm out at the Department of Correction.
Any of the other people on death row? I mean, are any getting close, or are they to actual having a death warrant, or are they still all tied up in the appeals?
Well, we always hesitate to say kind of like who's next
Right, right.
because we just don't know. Obviously, Tom Creech is in a position where he should have been executed. Pizzuto is in that same position. Robin Rowe's case is now in the Ninth Circuit Court of Appeals. My brief is due in the next few months. But the others are decades away.
Hmm.
Harrison is getting, he's over in federal district court on what we call a Martinez issue. And we don't need to get into the minutia of what that is, but yeah. But that is, I probably ought to mention that when we talk about delay, one of the problems in death penalty litigation is that the law is constantly changing and evolving. In 2000, and I believe it was 2012, the United States Supreme Court issued an opinion called Martinez versus Ryan, and it turned federal habeas litigation on its head, completely changed the rules of engagement. And then they came out with Shin versus Ramirez a couple of years ago, and it was another landmark decision that really changed federal habeas litigation. There are a lot of changes. If you're an attorney that really likes change in the law and dealing with constitutional principles, capital litigation is for you.